All right. Welcome, everybody. My name's Dan Kaplan. I am co-chair of Foley and Lardner's National Labor and Employment Practice Group. We have about 100 attorneys nationwide in about 25 offices. And we are very pleased to welcome you to our webinar this morning, titled Critical Wage and Hour Developments for 2023, New Minimum Wage Laws, Paying Day Rates, and the Department of Labor focus on pay equity. I am fortunate to be joined today with three colleagues from our National Labor Employment Practice Group. We're going to start out with Brooke Bollinger from our Dallas office, followed by Michael Ryan from our Houston office, and then Carrie Hoffman from our Dallas office as well. If you'd like to add a question, or if you have a question that you would like addressed during the presentation, please feel free to use the chat function. And please let me know in that chat function anything you are looking for. I'll intersperse questions periodically, but we'll try and hit as many of the questions as we can, especially at the end, time permitting. The presentation is an hour. And as I noted, there are three parts. Each part's about 15 to 20 minutes in length. You will see the PowerPoint is also going to be available on our website, I believe, as will the recording. And so you can get all that information there. And then we can also send you a copy of the PowerPoint if that's something that you would like to see as well. A little bit of background on the folks here. And now, Liz, if you take us to the first slide, please, we'll get started with Brooke. Thanks, Brooke.
Thanks, Dan. Hi, everyone. As Dan said, I'm Brooke Ballinger. I am located in Foley's Dallas office and am a member of the Labor and Employment Practice Group. I'm going to be tackling the first topic today, which is minimum wage increases. Just to start out, before we dive into the state issues, the federal minimum wage obviously remains at $7.25 an hour and has since 2009. There's been a few efforts to raise the federal minimum wage, the most recent being the Raise the Wage Act in 2021. None of those efforts have gained real traction. And so most of our discussion today will be focused on state and local laws, hence the list that you see on your screen today. The theme as well is going to be that this is an ever-changing landscape that gets pretty complicated because of the different layers, and as you can see, the different effective dates for minimum wage increases across the country. There's really three buckets that states fall into when they're approaching minimum wage increases and when they implement those. The first is some states really target a threshold, meaning they aim for the minimum wage to reach a certain amount. For example, New York had implemented strategic increases across time to reach $15 an hour specifically. And the second bucket that states normally fall into is they implement laws to reach a certain wage. For example, like New York reaching the $15 an hour wage. But then after that wage is reached, the laws take into account increases for inflation, which are usually based on the Consumer Price Index and normally come out around September. The State Department of Labor usually post those on their website to give employers notice of those going into effect. The third bucket that states usually fall into is not aiming for a specific wage, but just having increases in place based on inflation. Those would be Arizona and Washington are a few examples. And Connecticut, which is one you see on your screen today, not only does it have different effective dates over time, as you can see in 2022, the minimum wage increase became effective in July, and this year it becomes effective in June. This is part of the state's initiative. There's a 5-year plan to get the minimum wage to $15 an hour, which it will reach on June 1st of this year. And then after that, the state allows for adjustments, like I mentioned earlier in the second bucket, for inflation and things that are happening in the economy, which it bases on the Employment Cost Index and will account for those after June 1st of this year. As you can see, the different states, and Chicago being an example of a local law, have different effective dates, which makes it a little more complicated to keep up with when these go into effect and when your workforce needs to be in compliance with these wage and hour laws, specifically if you have maybe a remote workforce or just generally a nationwide workforce where you have employees across the country. One of these that I wanted to highlight specifically is Michigan, who currently has a minimum wage of $10.10. But to add to our theme of the ever-changing landscape and things that employers need to be cognizant of, especially if you have employees in Michigan, is that there's current litigation pending. The most recent update is the plaintiffs appealed to the Michigan Supreme Court. If that appeal is successful and the plaintiffs prevail, the minimum wage in Michigan would raise to $13.03, so about a $3 difference from the current minimum wage. But that's just an example and something I wanted to highlight of state and local laws that are ever changing. There's at times political things at play but from the court process that's taken place in Michigan so far, it's probably what will probably happen is if the appeal is successful, the state will give employers probably 2 months or 3 months to implement and make sure there's processes in place that if the minimum wage raises the $3 to $13, excuse me. Next slide, please. So in addition to the layers that I've discussed earlier, where these states are implementing minimum wage increases in different ways, whether they're targeting a specific wage or they're basing it off of the economy, or maybe a combination of both, there are other intricacies at play. For example, some states base the minimum wage off of the employer's revenue. That would be a state like Minnesota. Nevada, for example, bases the minimum wage off of if employers offer qualifying health benefits. And then obviously another piece to that is just the size of the workforce in general, which you'll see in some of the local laws on the right of your screen, base the minimum wage off of how many employees this employer has, and the minimum wage will differ based on that. Minnesota specifically, if the employer has over 500,000 in gross revenue, they're usually considered a large employer and will have a higher minimum wage than an employer that does not meet that gross revenue threshold and therefore will have a lower minimum wage. Nevada, as I stated earlier, it depends on if the employer offers qualifying health benefits. The legislature defined qualifying health benefits, which is helpful. In January 2020, it's essentially a list of, it's pretty extensive list of benefits that an employer has to offer, in addition to a few other details, in order to qualify, or for lack of a better way of putting it, be able to pay the lower minimum wage. So as you're taking into account whether the workforce is in compliance and where your workforce is and the effective date and all of these different details, it may also be helpful to review your benefit plans or what you're offering employees to, especially if you have employees in Nevada, to figure out if you qualify or which wage should you be paying based on the definition of qualifying health benefits.
Hey, Brooke, quick question for you. You did mention, depending on where your employees are located, should employers be paying attention to the residence or location of their employees for purposes of minimum wage application if they have a remote workforce?
Yes. Generally, the location or residence of the employee is the applicable minimum wage. And especially in the shift to a remote workforce, it's especially important that employers are keeping up with their census, and the specific part of that employee census being where your employees are located, because different laws, as you see, will apply as far as minimum wage. So yes. On the local law side, to add, oh, Dan, I'm sorry, did I interrupt you?
No, I was just saying
Another
thank
question? Okay.
Nope.
On the local side, just to add more layers to an an ever-changing landscape and something that can be quite complicated, especially for employers with remote workforces or nationwide workforces, is, as you can see from the first bullet, California by itself has approximately 40 cities or counties with their own minimum wage laws, the highest of those being currently $17.95, and it varies in between, which can be difficult to keep up with, especially if you have employees throughout California. There's a few other examples of counties or cities that also increase minimum wages or have their own minimum wage laws that employers should be cognizant of. Chicago, as I mentioned earlier, is dependent on the employees or the workforce size, excuse me. For example, if the employer has 21 or more employees, the applicable minimum wage in effect in July of this year will be $15.40. And Seattle is kind of a combination. It depends on the employer size and also if certain benefits are being added. So there are different layers and intricacies to each minimum wage law, which makes it difficult. And we'll address later on in this presentation proactive steps that employers can take in kind of tackling what can be a daunting array of laws that we need to be in compliance with to avoid liabilities and penalties associated with wage and hour laws. Next slide, please. Along with minimum wage increases, these are a couple examples of exempt employee threshold increases that took effect in 2023. California's is currently a little above 64,000. Washington is a little above 65,000 this year. And I'm saving Colorado for last intentionally because it increased to around $961 a week, which results in about a $5,000 a year difference in the 2022 threshold. But specifically, this can be important if you have restrictive covenants with employees in Colorado. The current law in Colorado in regards to non-compete specifically requires that non-competes can only be entered into with highly compensated workers. So along with the exemption threshold that increased, the highly compensated worker threshold also increased to around 112,000. And this is important and something I want to highlight where wage and hour can kind of, for lack of a better way of putting it, bleed into other areas of your workforce or what you're trying to enforce within your workforce, specifically restrictive covenants. Because the law requires that at the time it's entered into and at the time it's enforced, this threshold must be met. These types of increases are important for kind of going back and evaluating not only your handbooks or just your payroll and things like that, but also your restrictive covenants, especially if you have Colorado employees. And I've left a question mark by Pennsylvania because it's another example of the ever-changing landscape and the complications that can arise when an employer is dealing with a workforce that is nationwide. In October 2020, the Pennsylvania Department of Labor issued a rule, that would implement a threshold increase for exempt employees that would occur in October of every year. In 2021, during budget negotiations and political conversations, that rule was repealed and currently the federal thresholds apply, but it's yet another example of the ever-changing landscape of these laws and how quickly things can change for employers if you have employees in states that are trying to implement these increases. Next slide, please. So what can employers do to overcome this burden or the landscape at play here if you have a remote workforce or employees located in several locations? One thing is something I mentioned earlier is maintain updated information on employee locations. This goes directly to Dan's question earlier as to what law applies. It's going to be where the employee is located, and so making sure you have up-to-date information on where exactly your workforce is will give you the best means of making sure you're in compliance with these laws. Another thing is obviously reviewing the minimum wage and exemption threshold increases as they occur. This is usually something you should probably be doing as a best practice annually, as that's usually when these increases will go into effect. And as far as when exactly in the year, because we have those 3 buckets, it'll depend on the states. But for the states that are dependent on the Consumer Price Index, there's a large group of states that wait until the September evaluation or analysis comes out and will then post what the minimum wage increase will be on their respective Department of Labor websites. So that may be a good time of year as a best practice to start looking at these things for the upcoming year. Another piece of that is notice requirements. When these minimum wage or exemption threshold increases go into effect, some states also require that employers notify employees of these changes. That is how this notice goes out is dependent on the state, but it could be an intranet posting, maybe an email communication, or simply a physical copy posted at the workplace. But that's another detail that should be taken into account and something that should be reviewed as a best practice when you're evaluating your wage and hour compliance. Another thing is obviously your handbook policies, reviewing and updating your timekeeping and overtime policies can help to make sure you're in compliance and give employees a good insight on how you expect them to keep accurate time records and what you expect them to do as far as overtime. Another thing you can do, which is more really on the back end and process based, is ensuring your payroll department or respective HR department are aware of these changes and you've had a conversation about how these processes are going to be put in play, and then perhaps how you're going to deal with or manage communicating these changes to the workforce or to the applicable employees that it affects. Next slide, please. This is a brief overview of what happens if compliance is not reached. On the federal side, obviously, you can be liable for back pay or back wages. There's civil penalties, which are associated per violation. Willful violations have a heftier fine, and you can be subject to criminal prosecution, There's also certain liabilities and penalties associated with state and local laws. For example, Nevada provides that if an employee prevails on a wage and hour claim, attorney's fees are automatically awarded to that employee. And states like California, New York, and others also award liquidated damages in cases where wage and hour is not in compliance.
Hey, one quick follow-up, Brooke, for you. There was a question in the chat that was expressed after my original question. If an employee resides in one state, but travels to another for work and regularly works from the other state, which state's minimum wage law should be utilized?
I think it depends on what type of work is being performed, how much time they're spending, but generally the state where the employee is located should apply. I'm not sure of the details of this situation, but it could depend on the state or local law at play, what type of work they're performing, how long they're performing that work. There are those layers and intricacies involved as well, which can make this analysis a little more complicated.
Yeah, and I think I would provide a little extra guidance here as well. Remember, people can live wherever they want. One of the keys here is where's the work being performed. For remote workers, they're typically doing their work from their home. But if you have somebody who's regularly traveling across state line just because they live in another state, if they're coming across the state line, for example, they live on the Wisconsin-Illinois border, they live in Illinois, but they actually work in Milwaukee or Kenosha, you're going to apply that locales where the work is being performed minimum wage law. Awesome. Thanks, Brooke. Really appreciate all the updates on the minimum wage information. I think we're going to turn this over now to Michael. Michael, I know the Supreme Court recently gave us a discussion on Helix, and that this has particular application to a lot of employers that are in the energy industry. So if you'll kick us off about Helix, that'd be great.
Absolutely. Thank you, Dan. And I'm going to talk today about Helix both as it specifically pertains to the energy industry and oil and gas, where it's most common to see day rates, but also how that day rate concept and what the Supreme Court ultimately ruled has applicability outside of the energy space. So if you're not in the energy space, you're still in the right place on this webinar. But Helix is an opinion that we have been looking forward to for quite a long time because it was going to settle a very big issue in the oil and gas space, particularly whether or not you can compensate employees on a day rate and still comply with all of the strictures of the FLSA. And the resounding opinion of the Supreme Court of the United States is you cannot. So I'm going to briefly walk through the case for people who are unfamiliar and then really focus on what are the takeaways. How does this apply to you if you're in the energy space? How does this apply to you if you're not in the energy space? What if we don't have day rate workers, but we have these issues of exemption and classification? What do we take away from Helix? That should be hopefully what you get out of this. So, but let's talk about the case itself first. Michael Hewitt was a tool pusher on an oil rig in the Gulf of Mexico. Tool pusher, basically a foreman or a supervisor. He primarily performed administrative and executive functions on the oil rig. He managed the workers that were doing the brunt of the blue collar work operating the oil rig itself. As one of the primary persons in charge of the location, he was really highly compensated, over $1,000 a day on average and over $200,000 a year, despite working what we call hitches, 28 days where he would work on the oil rig and then he would take 28 days off before he even came back. And through that, he was paid well above the highly compensated employee exemption threshold, which for his case was $100,000 and has since changed. I believe it's about $107,000 this year. It is now tied to the price increases with inflation, so it'll go up every year. Because he was paid so highly, Helix took a very interesting approach. They designated him an employee and an exempt executive employee who met the highly compensated employee exemption to the FLSA. They didn't pay him overtime, and they paid him on what we call a day rate. Every day he worked, no matter if he worked for 1 hour that day or the full, 8, 12-hour day, he was paid his amount between $963 and $1341 a day. That became an issue because it didn't guarantee him a salary for the full week in which he worked, which is the typical standard of what a salary is under the FLSA. If you work 1 minute in that work week, you get your full salary as a salaried exempt employee for the week. Because Helix classified him that way, litigation ensued. And very interestingly, as the case progressed, and can we advance the slide? The only dispute was that he wasn't paid on a salary basis. Typically in these FLSA cases, you dispute whether or not the duties met the threshold for exemption. Was this truly classified as exempt work? That wasn't at issue here. And based on how much he was being paid per day, there was no question that he met the salary threshold. In fact, he made more on a per day basis than you needed to make on a per week basis in order to qualify typically for those exemptions. So Helix felt really good about where they stood on the exemption because they're highly compensating Mr. Hewitt for his work, and his duties are unquestionably exempt in terms of their nature. And that's exactly what Hewitt agreed to. And I've spoken with the attorney that represents Mr. Hewitt, and he was so bullish about this. He's like, we give up on the duties requirement. We don't need to worry about that because it's just so clear that this doesn't meet the very strict standard under the statute for what is a salary basis. And that's what this case turned on. It's very narrow in its scope. Essentially, Helix said all the things I just said. He's exempt. We're good. We paid him well over $100,000. His duties are clearly the type of duties that are exempt. And then Hewitt responded back, not so fast. I have to be paid on a salary basis. This means that for any given week in which I work, I have to be guaranteed, they call it a guarantee of that amount of money that I will make that week. But as the majority opinion in the case spelled out, that wasn't how Hewitt was paid. If he worked 1 day that week, he got paid $1,000 roughly. If he worked 2 days that week, he got paid double that amount. And they said that's exactly why this was not truly a salary basis as the statute defines it. And so the Supreme Court, interpreting the statute very specifically, said this does not apply to Mr. Hewitt. He is not an exempt employee. You got to pay him overtime. Obviously, as employers, having someone make over $200,000 a year and have to get paid overtime for, working 12 hours a day, 7 days a week, you're talking about substantial amounts of overtime for those individuals. What's there to do? How do you handle this? We thought we were good paying him this much money on a day rate. I wouldn't think that the FLSA would cover someone who is that highly compensated. And next slide, please. What the Supreme Court said based on an interpretation of the FLSA is employees are not deprived of their right to overtime just because they're well paid. The main criticism I've heard throughout my entire career about the FLSA is that it was written in 1938 and it applies as sort of the law was intended to be applied in 1938 to the predominant industries back then. At that time, they probably didn't envision someone making this substantial of a salary and getting overtime on top of it. But that is the statute that we have. That's the law that must be interpreted. And one of the main takeaways is that the Supreme Court is going to take this statute, read it very clearly, and then apply it as written, no matter if the result seems a little bit absurd on its face based on how much this guy got paid. Dan, you got a question?
Yeah, actually, Michael, a couple of quick questions for you. One is,
Sure.
Would Helix have been able to take advantage of the exemption had, instead of doing a day rate, they just merely changed that from taking whatever a day rate was for the week, multiplied it by 5 or 7, and then just converting it to a weekly salary?
Yes, and in fact, the opinion itself speaks to that. The majority opinion says they could have cured this issue if they had said, look, you're going to work 7 days a week, 4 weeks straight. So that's $1,000 a day, $7,000 a week. You're going to get that. But Helix didn't want that because what's going to happen is you're going to find he works one day and then he gets sick the rest of the week. And like a lot of employers that don't want to give an exemption for individuals that maybe, won't work all the time and consistently, they didn't want to be paying $7,000 in a week when 1,000 or 2,000 would be appropriate. And they felt that was more than fair, but they could have met the exemption by doing exactly what you're describing.
Is there another salary methodology of compensation, maybe not for an exempt employee, but for a non-exempt employee that also could have been utilized?
Absolutely. So, I mean, the key here is that there was no question that Hewitt was exempt, but that's not going to be the case for a lot of employees. That would be a much closer question. And one of the takeaways from this, whether you're in the energy industry or not, think about it as I have an employee that I'm not certain should meet the exemption, but I want to pay them on a salary basis, both because traditionally that's how this job has been paid. That's what the employee comes to expect. It gives me a little bit more of a certainty in terms of how much I'm going to outlay for the payroll for that week or that month. A lot of employers will switch individuals to, minimum wage and overtime to try and avoid this day rate issue under Helix. But what Dan, you're talking about is the fluctuating work week method. So this is the way you can pay someone a salary, even though they are not an exempt employee. And the way that the fluctuating work week method works is very complicated, not really, but it's very nuanced and you have to follow each of the nuanced strictures. So at first it seems very complicated because you have to understand all of the different procedures you have to follow, and the base hourly rate changes from week to week, so it looks like it's impossible to calculate. But once you get the hang of it, you really start to be able to see the benefits of it. You say, hey, you're an employee who's going to earn roughly $1,000 a week under the salary. Well, I'm going to pay you $1,000 a week, whether you work 1 hour or 50 hours. And if you go over 40, if you would be entitled to overtime over 40, we're going to figure out how many hours you actually worked, whether that's 41, 51, 61. Divide that into the base salary I paid you that week, like $1,000. And then that'll tell us what your minimum base straight time pay is for the week. Then you multiply that to get overtime. So why would an employer do that? The whole idea is the more hours you work, the more overtime you earn. But under the fluctuating work week method, the more hours you work, the lower your straight time rate. And as long as it stays above minimum wage, it is an acceptable straight time rate. So if I worked 50 hours and I earned $1,000 a week, my straight time rate is $20 an hour. But if I worked 60 hours and I earned $1,000 a week, That straight time rate is something less than 20. I'm not going to do the math here and expose my lack of math skills, but it would be less than $20. And so when you did that time and a half calculation, it would also be lower than it would be if you just said, you're salaried, but we got to switch to minimum wage and overtime, or straight time and overtime because of the Hewitt decision. We're going to pay you $20 an hour. Well, in that week where it's 50 hours that week, that makes sense. But in 60, 70, all of a sudden your overtime bills are getting a lot higher. So that's one other alternative. Dan probably went too far on the fluctuating work week method, but now everyone has that.
Thanks.
Can we switch to, you're welcome. Can we switch to the next slide, please? So this is what I really want to focus on for the remainder of my time is what can we do about this? We're not in the energy industry, or we are. What do we take away from Hewitt? How do we interpret this and apply it to our business? The main thing is almost everyone on this call, I would imagine, has exempt employees of one kind or another. And whether you pay them on a day rate method or not, you need to be looking more closely at those exemptions, because it may not be a day rate issue. It may be a job duties issue. But whether or not your person and employees are exempt is coming under strict scrutiny by the Supreme Court. And this will not be the only challenge we have. It was simply a very obvious and open one that was brought up to the Supreme Court's attention. So as we start to see potentially changes in the minimum salary thresholds to be qualified for an exemption in 2023, or as we see possible changes to the job duties test that's been floated out there as something the DOL might try to change in 2023 or beyond, that may affect who is able to be classified as exempt, and you need to be evaluating that. There's also the issue of exemption under both state and federal law. So if someone is exempt under federal law, but they work in, say, California, where the exemption amount, the minimum salary required to be exempt is higher, you need to be cognizant of that as well. You also should evaluate your pay practices, because what we're seeing so far, and it's only been a month or two since this decision came out, but what we're already seeing is employers saying, how do I fix this? How do I make sure that I don't have the issue that Helix had? A lot of them are switching people who are questionably exempt or that were paid on a day rate, switching it to hourly and overtime. That may or may not be possible for your business, but if it is, the short-term effects and the higher cost associated with hourly and overtime might be mitigated by the avoidance of litigation. But you got to remember that when you start going to those rates, traditionally these industries that are paying a day rate are also paying per diems or spot bonuses, and those can factor into the straight time rate to determine what the overtime rate is. So you have to be very careful with how you convert employees. And then also, if you're converting them, they were salaried, they go to hourly, we all kind of know that issue can trigger people to say, wait, does that mean I was misclassified? Does that mean I have a case too? And so for the 3-year look back period for misclassification cases, you have an open risk that someone could try to bring that case. Another thing is, if you were paying someone on like a day rate or as an independent contractor, which is an analogous issue, but it was not covered by the Hewitt opinion, you can see this issue coming up with benefits. Was I not provided to them before, but now I'm switching them to hourly and overtime, so I need to give them benefits? How does that factor into my costs, and how do I go forward from there? So the issue is narrow at one view, right? Hewitt was in the oil field, in the energy space, but the interpretation of the FLSA is extremely, I use the word draconian. It's just, this is what they said in 1938, so that's what we're going to do. And it applies because that's how the FLSA is going to be interpreted by the Supreme Court for a long time. And so if you have any questions about the classifications of your employees, you might want to start looking at, do we need to adjust, even if they're not paid on a day rate, because those are coming under stricter scrutiny. One sort of don't do this anecdote that we saw for many years in the oil space is that they said, okay, I can't qualify them as an exempt employee. I don't want to pay hourly and overtime. How do I get around this? Oh, I know. I'll just send them to a staffing company. I'll pay the staffing company a day rate to supply me those workers, and how they pay those people is not my concern. We saw this for decades. You may have that happen at your business, and that is equally the subject of litigation, for better or worse, in that sphere of the compensation model as well. One thing that I found very interesting is that we are starting to see some of those staffing companies take the day rate from the end user company that they're sending the workers to, but they're paying minimum wage and overtime or a straight time and overtime model because they need to try and comply, even if they're not the end user employer, with these FLSA requirements, and they know they can't get around them. So Hewitt is sort of a warning signal that you want to make sure that your exemptions are up to board, because otherwise they will get challenged and it can be very costly. Dan?
Michael, one more quick question before we
Sure.
move to Carrie. I know that there is litigation out there right now where somebody is actually challenging the requirement of a salary as a component to find an exemption. And I believe at this point in time, that litigation may be at the district court or court of appeals level. Do you see or do you foresee the salary requirement for exempt status going away anytime soon?
I don't, especially with sort of, I would think that an act of Congress would be required to amend the regulations that govern this and that require that salary basis. I would see amendments to the salary minimums, right? How much is required, but I wouldn't foresee any change at the courts to requiring there be some form of a salary in order to be exempt, because that is mainly the reason for the exemption, right? What are you being exempt from? You're being exempt from paying a straight time plus overtime model. And so the alternative to that is paying a salary, paying something that is more of a flat per pay period as opposed to that overtime model. So absent Congress changing it, and even theoretically just the conceptualization of it, I don't think that will survive.
Thank you, Michael. Thank you very much for the discussion of Helix. Very interesting. I think right now we're going to turn over the presentation to Carrie Hoffman. Carrie's going to start addressing pay transparency and pay equity and what the Department of Labor is focusing on in this space.
Good morning, good afternoon, everybody. So big picture, pay transparency laws are sort of taking over. They're a 2022-2023 concept. Big picture, legislative bodies across various states are looking to target historical issues of pay inequity. One of the things that we've seen and heard for a long time is that women and racial minorities tend to make less money because they've always made less money, and I'm paying you. You make $10 an hour at your job. I can recruit you for $10.50, but I pay all the guys who've been here longer $11 an hour, however that works. And so there's a lot of issue with that. And these laws are attempting to target disclosure of pay ranges, pay hourly rates, salary rates, and that you can't simply just tell someone you're going to pay them a little bit more than what their current job is and get away with it without some disclosure of that, which then puts the individual applying for the job in a different position with respect to negotiating compensation. Obviously, when we go through these pay transparency laws, as we're about to by various state, remote work can make this more complicated. And there are certainly states, as we'll talk through, who've basically said if the job can be performed remotely, but the work is, quote, in New York, whatever that means, it doesn't matter. If the person could be sitting in New York and doing the job, even if it's in California, you may as well just comply. So to the extent you're advertising and having discussions with applicants for remote work and you don't care where they sit, you need to take that into account as you figure out compliance, because that's going to be an issue as well. Previously, this was very limited to pay information when people required it or requested it in various states. But as we'll walk through, if we go to the next slide, it's become much more aggressive from a state law issue, meaning they're really looking for true transparency. Colorado's law came into effect in January of 2021. And it required employers to give salary and benefit information to applicants and employees, explain both promotional opportunities and opportunity for growth, and apply to remote work. Again, as we all learned from the pandemic, remote work has taken over kind of the concept of these state law issues and made it much more difficult to claim, the state law of where the employer is based is applicable. So it's something to definitely consider. and addressed essentially concerns about the proprietary nature of compensation information, that they didn't think it was a big issue, meaning what you pay to an employee isn't really proprietary in their minds, and that's why the law went into effect. It's about open disclosure, again, so the employees have the ability to look at it. Colorado's law applies to all employers regardless of size. We'll see that some state laws apply based on employer size. But again, from a big picture perspective, this is sort of what kicked off that issue. And again, the title of the statute describes what it's for: equal pay for equal work, meaning we're attempting to get rid of whatever historical biases could have existed in your pay scales, because again, you're employing people traditionally in lower paying roles based on those kinds of issues. If we can turn to the next slide. New York then jumped into the fray, if you will. The New York City law went into effect in November of last year. It applies to employers with 4 or more employees. It's about posting wages and or ranges, but doesn't impact benefits, meaning you don't have to disclose PTO and health insurance and those kinds of things. The New York state law is more broad. It also applies to employers with 4 or more employees. It'll take effect in the fall of this year on September 17th. But it requires employers to provide job descriptions to employees. It clearly says it applies to remote work. So any work that could be performed in New York State, because it's remote, even if you're not necessarily targeting New York State employees, this law applies to. It requires you to post as an employer minimum and maximum salary or hourly wage ranges, again, to the extent you have those ranges. And like I said, is very broad, requires you to keep records of what you've done to provide that level of detail and information to employees as they're applying for jobs. And again, big picture, you should expect that this is going to apply to both applicants and current employees as you are looking at promotional opportunities that are internal as well. Next slide. The Washington state law took effect in January of this year. It applies to employers with 15 or more employees, requires employers to disclose scales or salary ranges and a general description of all benefits and other compensation. Is the job bonus eligible? Is overtime required? Again, these statutes should be interpreted pretty broadly, because the intent is for employees and applicants to have true knowledge of what is available to them, whether that's about negotiating a new salary or whatever that may be. And then the disclosures required for internal transfers and promotions as well, meaning we're not only doing it for new hires, it applies internally with whatever opportunities exist for your existing and current employees. The California statute also took effect in January of 2023. It also applies to employees with 15 or more employees. It requires that pay scales be put in all job postings. It has penalties associated with it. Of course, it's California, so it does. Again, based on the violation, it could be $100,000 to $10,000 per violation. It very clearly, like New York, says we don't care where the person is sitting, meaning if they could be in California, even though you may be based in Minnesota, but you're hiring remotely, it means your postings have to comply. So that's what I'm trying to talk about with respect to the breadth of what these statutes are talking about with remote work. When you're advertising for a remote position, even if your intent is not to hire someone in California, someone in California could be reviewing it and considering applying for it, you're going to have to comply with that state's laws, for all of these state laws. So you should probably get used to basically providing that level of detail and information. Next slide, please. Other states are joining that trend. Maryland's requiring employers to provide applicants' wage ranges when they request it. Obviously, it doesn't have to be posted since it's upon request. But as these laws sort of take effect, we should be planning and predicting that we're going to get more requests from employees about this kind of information. Same issue, Nevada requires that information to be provided to anyone you're interviewing for a job. and to provide it to applicants for promotions and transfers, or anytime they've completed an interview and asked for it. So again, being prepared to provide that information is going to be important, meaning we need our recruiters to be armed with the information they may be requested. And we want to make sure from a standpoint that we know why it is we're providing the range we're providing, and that we're comfortable with it, that it's accurate, and that we're hiring within that range. Same issue, New Jersey requires employers with 4 or more employees to include in job ads the minimum and maximum annual salary or minimum and maximum hourly range for the job. So again, we need to be cognizant of how we're promoting potential opportunities and providing that level of detail. Rhode Island requires the range to be provided to applicants upon request, and that at the time of hire, the entire range of that job needs to be provided to the new hire. So even though you may have hired someone at the bottom end of a range, you're not going to avoid letting them know that others are making more money than they are, which can, of course, create issues. So we want to make sure, as we're offering new compensation to employees, as we're hiring them, that we're comfortable with the way we're offering salary information to them, so that we can defend any claim that they're not being properly paid. Next slide, please. So obviously I've been saying it's the trend. We should assume it's the new normal. And again, unless you're advertising for a position that can only be performed non-remotely in a state that has no such law, you should be expecting to be providing this information. I think big picture, this is a good training opportunity for HR and managers to understand the company's pay policies. How do we establish pay ranges? Are we paying based on geography? And if we are, can we defend that when we're dealing with remote workers, so that we understand why we're making pay decisions that we're making? And then we need to understand what data is being looked at for competitive purposes, meaning if we're providing this information, our competitors are going to be able to see it as well in all these job postings. Are we comfortable that we're competitive with whatever we need to do to compete for workers? Again, making sure we have an understanding of remote work. That becomes, the big issue all the way around. So are we comfortable that we are in compliance with minimum wage issues in various states as we are dealing with the remote work, and we're disclosing those types of information in our pay ranges and salary ranges? And then making sure that we can look at our current comp and make sure that we don't have unjustified pay differences, so that if we have claims that someone is being underpaid in comparison based on race or gender, we can defend that claim because we know we have a justified reason for it.
Quick question for you, Carrie. When an employer is required to provide a range or post information about pay transparency, or provide the information on pay transparency, is the employer supposed to use the range that it is personally considering? For example, if it's going from a middle, you're going to use the midpoint to a 3/4 point, and therefore they use a shortened range? Or should they be posting the widest range? Is there a prohibition against posting a range that's $500,000? What's the best practice in this space?
Yeah, I mean, the best practice is to really look at your compensation levels. And I mean, a $500,000 range is probably not realistic in most jobs, although, it's certainly possible. Most people aren't applying for, the entry-level job and CEO at the same time. It's really to look at what's the range we're paying for that job, what's the lowest we pay for that job currently, what's the highest we pay for that job currently, and are there adjustments that need to be made based on that? And that's part of that review of, do we have unjustified pay differences? But the range should really be what's accurately out there. And a $500,000 swing is likely too much for most jobs and probably not realistic. And so this is intended to be, something where someone can say, well, I'm only making 10, but the minimum range for this job is 12, and that those disparities that are based on history go away. And so that's what the intent of the range is, and that's the way you should frame your disclosures. So since we're still talking about pay all day, the EEOC's pay data requirements, they're telling you now this is coming back. You're going to have to provide pay data to the EEOC as part of your EEO-1 report. Again, the EEOC as we're going to talk about in a minute, and the DOL are really targeting pay discrimination as potential risks and issues for employers, again, based on sort of the historical nature of pay discrimination in this country. So those are considerations as we're looking at and dealing with your EEO-1 report, and things that should highlight red flags from an internal perspective. We still have to provide the information, but what to do with it. California's pay data reporting requirements, same issue, starting in May of this year. You're going to have to provide pay data to the Civil Rights Department, formerly the DFEH, and then do it every year. So again, this applies to private employers with 100 or more employees. And again, California-based employers are going to have to contend with that issue. Michigan is looking at similar laws. They haven't passed them yet, but big picture, they're looking at pay transparency laws and other things like that. And then let's move to the next slide. The DOL's got a focus on pay equity, as I indicated, and the OFCCP, which applies to all federal contractors and subcontractors, has issued a directive in the fall of last year. And it's essentially a guidance as to how OFCCP is going to evaluate federal contractor compliance with their compensation analysis. They've announced that pay discrimination is a top priority for the OFCCP in the coming months and year. And something that if you are a federal contractor or subcontractor, you should be looking at to make sure that you could defend yourself if you get called for an audit. The DOL is recommending employers conduct an internal review. Obviously, big picture, those are things you should consider doing, whether you want to involve inside counsel, outside counsel, so that they're privileged and don't have to be disclosed, is a larger topic than where we are. But looking at your pay and pay equity within your federal contracting or subcontracting obligations is a good idea, because it is going to be the focus of audits going forward. Next slide. This big picture is they're going to require you to prove that you've done a compensation analysis, meaning they're going to require contractors to be able to do that. And they're going to look very broadly at your workforce to look for patterns of discrimination by pay, by race, ethnicity, and gender. And again, potentially assignments, placements, and promotions that can drive pay disparities. So again, this is looking at long-term big history and making sure that you can defend pay practices that may, again, be more than 1 year old. And those are big picture issues to consider as you're looking at conducting your own internal compensation analysis. Next slide, please. And again, they're very committed to this pay issue, and have highlighted on the payday fact sheet, the link is here, these kinds of things, pay secrecy policies, not being able to talk at the water cooler about how much you make. As I've talked about, relying on past salary history can create that problem. The stereotyping and steering of women and or racial minorities to lower paying positions, again, not looking at those types of issues from a long-term history perspective. Looking at only subjective factors when it comes to compensation, meaning, if Supervisor X always gives bad reviews to an employee, they're going to not make as much money. Those are completely subjective factors, unless we're talking about outputs per minute that can be measured. Those kinds of things are very important to look at. Looking at your compensation system proactively as opposed to waiting. And then looking at big picture, one of the things they're focused on is the reincorporation of mothers back into work post-leave, post-time off from work, and looking at bias as it may apply with respect to compensation with those issues. And so again, these are the kinds of things the department's going to be focused on when they're doing their compensation reviews of federal contractors and subcontractors. Next slide. And then big picture, for those of you who decided not to pay attention to me because you're not a federal contractor, I do think this is the kind of thing that triggers private plaintiffs' attorneys in their focus, and that we're going to hear a lot more of these kind of pay disparity claims in discrimination context. And so it's a good thing to keep your eye on as we move forward.
Carrie, I think that's excellent advice. I think irrespective of the fact of whether you're a federal contractor or a subcontractor, this pay transparency approach is proliferating everywhere. And there's differences, as you've highlighted, depending on the state and depending on the locale. And we saw those same kind of differences with the minimum wage. Do you have a best practice to recommend to attendees on how to stay up on this kind of stuff? Or if they should be including salary ranges in all their postings, irrespective of the application of a pay transparency law?
I mean, big picture, the best way to stay up, of course, is to attend all of our webinars, Dan. But in the big scheme, some of that, if you have a payroll provider, I know I couldn't help myself. You set it up too well. If you have a payroll provider like an ADP, a lot of times they will publish this kind of information. We certainly publish it in our employment law perspectives that comes out once a week. Those are great ways to stay up. Otherwise, I do think rather than sit around and scratch your head about remote work, it's probably better to accept pay transparency as a reality. And unless you only have employees in one state and you know the state law doesn't apply and you're not hiring remote workers, it's probably a good best practice to start including it and not worry about it, because then you don't have to worry about being out of compliance. But we need to make sure that we can articulate the basis for our ranges and that our recruiters understand the ranges so that when they get questions about why offers are being at lower ends to an applicant, they can explain it. So we need to train people to understand why we're doing it and how we're doing it.
Yeah, I guess it's that that oft present reminder that training is key with most things that are labor and employment related. And I guess it's also key with recruiting as well in this space.
Yes, exactly.
Well, folks, I think is there a final slide here? We've reached the conclusion of our critical wage and hour developments of 2023. We're only a quarter of the way through the year, so I'm guessing that there may be further developments coming down the pike. I want to thank everybody for your attendance today. On behalf of Foley and Lardner and our Labor and Employment National Practice Group, we thank you very much. I know we have this scheduled for an hour, and so I'm going to end at exactly the 59th minute. And thank you all again.